On behalf of the Homer Drake Inn of Court and, of course, MACBAG, I'd like to welcome everyone to our program this evening. Glad you were able to make it out, and glad you were able to get in. Before we get started with our speaker, I thought I'd highlight a few upcoming events and talk about a few other things. And as a result, I made some notes. Let's see, first coming up, the next event after this event is the Middle District of Georgia Bankruptcy Law Institute. That'll be in Macon on September 20th. It's an all-day program from 8 to 4 at the Macon Centraplex. A lot of Northern District folks will be speaking there, including Judge Deal and Neil Gordon, who I've seen around here somewhere. So please attend that if you can. Coming up later in October, we have, actually the 11th Circuit is putting on local roundtable discussions among the federal bench, bar, and law students, something called Roadways to the Federal Bench. Who, me, a bankruptcy judge? So if you've ever been in our courtrooms and you thought, well, I could do that, this might be a beneficial program for you or people you know to attend to figure out what the pathway is for getting to have this kind of job. And I thought Judge Cavender is here, and I know he's been heavily involved in that. If you want to add anything about the program or...
Thanks, Paul. So the program, as he said, is October 24th at the 11th Circuit Court of Appeals. It will have about 24 judges from the 11th Circuit, U.S. District Courts from around the state, magistrate judges and bankruptcy judges. There will be a live broadcast from Washington, D.C. for the first hour. The second hour will be roundtable discussions between lawyers and the bench, where you can ask judges, hear kind of their roadway, how they got to the bench, and ask them questions if you have an interest. The goal of the program is to promote diversity on the bankruptcy bench and bar. There will be a sign-up starting September 17th, and we'll be able to send out a link to both MACBAG and to the Inn for people who are interested. Space will be limited. There will be 75 participants allowed to sign up, and there will be a nice reception afterwards where you can continue your discussions with the judges. So,
thank you. And then the Inn will conclude its year with the State Bar event out at Lake Oconee in December. One other thing before we get started, something that is, I guess, brand new. We decided to work with the Bench and Bar Committee to try and streamline some of our processes. And I think at this point I'll let Judge Saylor explain more about what we have in mind in that regard.
Thanks. So it's still pretty informal and in the beginning stages at this point, but essentially our thought is to request feedback from the bar about whether there are procedural issues that the judges, primarily the judges in Atlanta, maybe do a little bit differently from each other. You know, we like to think that we're consistent, but we don't always know what everybody else is doing. And even when we do figure out that maybe I do something a little bit different from Judge Bezier, we don't necessarily know which procedure really works best for the bar in terms of efficiency and all of those sorts of things. So we're going to put something together and send out a request. It'll come through the Bench and Bar Committee, but we will make sure that the Bench and Bar Committee sends that out through MACBAG and other relevant organizations. And the request will essentially be, provide feedback explaining specifically, we have to do 21 days in this courtroom, but 14 days in this other courtroom, or, whatever the procedure is, and then specify which procedure it is the attorneys prefer. And, we can't guarantee that we're going to adopt every suggestion. Obviously, everything has to comply with the code and the rules, and otherwise the judges have to be comfortable with it. But it is an effort for us to all be more consistent and make it so that we don't want you having to have a chart in your office for, you have to do these motions differently in all these different courtrooms. So that's the goal. Look for that to come out from the Bench and Bar Committee probably sometime later in September.
Thank you. I guess that covers it for me. And so I know we have everybody's excited about the speaker. I'm sure that's why everybody came, other than the terrific camaraderie that we do have. And with that, I'm going to turn it over to Chase to introduce our speaker.
Thank you, Judge Bezier. Good evening. Thank you for joining us. On behalf of MACBAG, I'm Chase McCallum. I'm here to introduce our wonderful speaker that we have this evening. Shayna Steinfeld is a partner of Steinfeld & Steinfeld, where she works with her husband, doing primarily family law and bankruptcy. She got her bachelor's, JD, and MBA from Emory. And in addition to being a partner at Steinfeld & Steinfeld, she's been a past president of the Atlanta Bar Association, the Georgia Association for Women's Lawyers, MACBAG, Georgia's Network for International Women's Insolvency and Restructuring Confederation, which she also co-founded. She's been a chair of the sole practitioner and small firm section of the Atlanta Bar and the bankruptcy sections of both the Atlanta Bar and the State Bar of Georgia, as well as past chair of the bankruptcy committee of the ABA Family Law section. She's currently the Woman Advocate Committee and Work-Life Management Subcommittee co-chair of the ABA Litigation Section, and a master in the W. Homer Drake Jr. Georgia Bankruptcy American Inn of Court. Although there are many more accolades and accomplishments to list, we're all eager for the presentation she's prepared for us this evening about preparedness and professionalism when dealing with the court. So without further ado, please join me in welcoming Shayna Steinfeld.
Thank you for that introduction. So I think most of you guys all know me and realize I'm a little bit like, I want to make sure you can hear. Is that good? Better now? Better? Maybe I'll just stick with that? All right. Is that better? That's better. Okay. So most of you know I'm a bit of a bar junkie. I love bar work, so that reflects in the resume. So it's very happy to be here tonight. I really appreciate everybody coming out. I chose the topic of preparedness and professionalism when dealing with the court. It's a topic that MACBAG wanted to address. It's a topic that the Inn of Court addressed in June back at a meeting we had in Macon, and decided it was appropriate to bring to Atlanta tonight. So in the next hour, we're going to combine lessons from the book All I Needed to Know I Learned in Kindergarten, and we're going to combine that with the Georgia Lawyer's Creed. And by the end of the hour, everybody will be eligible for their hour of professionalism CLE. And we will have discussed preparedness and professionalism when dealing with the court. And I'm going to invite discussion and especially encourage the judges who are present, and I really appreciate all the judges we have here tonight, and encourage all the judges who are here to join in and chime in. And just so you all know, I did contact Judge Hagenow before today and asked her to chime in, and feedback I got is also incorporated into the paper. So the materials have been, they have the aspirational statement on professionalism printed within it, and they may be referenced and reviewed, and I encourage y'all to read it. And it's also online at the State Bar website, and it is going to be so much fun to compete with the people on the other side of the curtain over there, and they're going to also earn their hour of professionalism credit. So anyway, and all I really need to know I learned in kindergarten, Robert Fulghum advances the following credo, okay? All I really need to know about how to live and what to do and how to be, I learned in kindergarten. Wisdom was not at the top of the graduate school mountain, but there in the sand pile at Sunday school. These are the things I learned. Share everything. Play fair. Don't hit people. Put things back where you found them. Clean up your own mess. Don't take things that aren't yours. Say you're sorry when you hurt somebody. Wash your hands before you eat. Flush. Warm cookies and cold milk are good for you. Live a balanced life. Learn some and think some and draw and paint and sing and dance and play and work every day some. Take a nap in the afternoon. When you go out into the world, watch out for traffic. Hold hands and stick together. Be aware of wonder. Remember that the little seed in the styrofoam cup, the roots go down and the plant goes up, and nobody really knows how or why, but we are all like that. Goldfish and hamsters and white mice and even the little seed in the styrofoam cup, they all die. So do we. And then remember the Dick and Jane books, and the first word you learn, the biggest word of all, look. Everything you need to know is in there somewhere. The golden rule and love and basic sanitation, ecology and politics and equality, and sane living. So take any one of these items and extrapolate it into sophisticated adult terms and apply it to your family, your firm, work, government, and the world we live in today. And these principles, they hold true, clear, and firm, okay? So, like the Girl Scout Pledge or the Boy Scout Pledge, we're going to all say this, the Lawyer's Creed out loud. And I want everybody to do this together, okay? And there's a reason for this, and part of it is to earn the credit, and part of it is because I think when we were sworn into the bar, we looked at it, and we haven't really looked at it since. And it makes sense, and it's going to resonate. So all together now, all right? Like almost raise your right hand, but no, we won't do that, all right? So to my clients, everybody together, come on. To my clients, I offer faithfulness, competence, diligence, and good judgment. I will strive to represent you as I would want to be represented and to be worthy of your trust. To opposing parties and their counsel, I offer faithfulness, fairness, integrity, and civility. I will seek reconciliation, and if we fail, I will strive to make our dispute a dignified one. To the courts and other tribunals, and to those who assist them, I offer respect, candor, and courtesy. I will strive to do honor and to search for justice. To my colleagues in the practice of law, I offer concern for your welfare. I will strive to make our association a professional friendship. To the profession, I offer assistance. I will strive to keep our business a profession and our profession a calling in the spirit of a public service. To the public and our systems of justice, I offer service. I will strive to improve the law and our legal system and to make the law and our legal system available to all and to seek the common good through the representation of my clients. So we're going to merge these ideas, the Georgia Lawyer's Creed and what we learned in kindergarten, and we're going to start with let's not hit people, okay? So, and I'm not a terribly good joke teller, so this is the only joke I'm going to try tonight. A defendant was asked if he wanted a bench trial or a jury trial. Jury trial, the defendant replied. Do you understand the difference, asked the judge. Sure, replied the defendant. That's where 12 ignorant people decide my fate instead of one. So, lawyer and judge bashing is good sport, but it's unprofessional and counterproductive. It violates the lawyer's pledge and creed. We have 8 bankruptcy judges in the Northern District. There are fewer in the Middle and Southern Districts. They each have an unbelievable arsenal of bankruptcy knowledge and experience. They've brought this experience to the bench. They have incredible educations. We as bankruptcy lawyers, we're really lucky. In the state court, in the superior courts, these lawyers appear, they get general jurisdiction. Courts, the judges don't necessarily have any experience at all when they go into those courtrooms. We're a specialty bar. There aren't that many bankruptcy lawyers in Atlanta or in the rest of the state. We see each other regularly. It's collegial. It's even more collegial if you participate in all those bar activities and become a bar junkie. Join, participate, become involved, and get to know your colleagues. Join, participate. This is part of the aspirational statement on professionalism, assisting in organized bar activities in order to improve the practice of law. It's part of the lawyer's creed. Participation in such activities is an incredible way for you to become friends with your professional colleagues. Sometimes the facts and the law are tilted in your favor. Sometimes you have the facts and the law is a bit gray. Sometimes you have the law and the facts are a bit gray. You will see the same colleagues for the next few decades. One case, one client, it's not worth sacrificing a reputation. Your reputation is your calling card. It's most of what you have. Once your reputation's gone, you can't get it back. We're collegial. We're sometimes referred to as cliquey, although I don't think most practitioners really intend to be that way. It's just the way it works, size-wise and practice-wise. Cases are not meant to be about the lawyers or even the trustee. They're about the clients who have specific problems that need to be solved and the underlying facts. Lawyers are problem solvers. Life is much too short to make any given situation personal. Bankruptcy lawyers should also honor the Atlanta Bar Association's Lawyers Pledge. As a member of the Atlanta Bar Association, I pledge to conduct myself in a manner that will reflect honor upon the legal profession. I will treat all participants in the legal process with civility. In every aspect of my practice, I will be honest, courteous, and fair. That's a theme that runs through a lot of this. Honesty, courtesy, fair. Honest, courtesy, fair. This is important because it may be that in your next case, your facts may be murkier or the law may be a bit grayer. And bankruptcy is one of those practice areas where the law is almost always gray. It's rare that we have something that's black and white. So the second prong of what we learned in kindergarten is don't hoard or otherwise share. We need to share or share. So the admonishment to share everything is applicable to many aspects of the practice of law, but it may be particularly appropriate in the area of discovery. Rules of evidence tell us that the object of all legal investigation is the discovery of truth. That's Federal Rule of Evidence 102. These rules, the federal rules of evidence, should be construed so as to administer every proceeding fairly, eliminate unjustifiable expenses and delay, and promote the development of evidence law to the end of ascertaining the truth, again, here's that truth, and securing a just determination. As officers of the court, we have an obligation to insist that our clients tell the truth, to engage in discovery in good faith, and to comply with the federal rules mandatory discovery under Federal Rule Bankruptcy Procedure 7026. The sharing mandate is also applicable before any and all hearings. Talk with opposing counsel before a hearing. This does not mean 2 minutes before the judge comes on the bench. This is with enough time before the hearing to actually maybe solve any problems or to fine-tune issues before the hearing. Share your position, share your exhibits, try to work out an agreement before asking the court to make a decision for you. An emergency should not be one that is created by the lawyer's failure to act. There should be sharing and communication. There's also, get this, control. You have control if you can work out your issues. When you talk through the issues and share beforehand and settle your own cases or some issues within your cases, rather than put the issues to the judge and let the judge decide the issues for your client. So the third prong of what we learned in kindergarten is don't break the rules or play fair. Ignorance of the rules is no excuse, and there are many rules in a bankruptcy case. There are the federal rules of bankruptcy procedure and there are the local rules. The local rules are available online on the court's website. I think everybody knows that. There are also general orders of the court, also available on the court's website. Whenever you are preparing to file something, check the judge's webpage, and see if their particular judge has a form, order, or notice to follow on any particular issue. And this dovetails into what Judge Sigler was saying earlier about there being some variations in how different judges handle different issues. You need to check the website, check the webpage, and see if there's something you need to know before you file something. Look for a local rule. Check the service requirements under the bankruptcy rules. Judge Massey, and I think some of you are new enough to the practice of law that you don't remember Judge Massey, but Judge Massey has a 24-page guide for how to properly serve items in contested matters, and the court has updated and maintained this document on the website. It's pretty detailed. It's really excellent. Check it out, follow it, look for how to serve something. Because the truth is, if you get it wrong, you're going to have to go back and do something again. So you might as well try to get it right and check out the guide. There are also rules. There's a good guide on the court's website for things like motions to avoid a lien. So if you need to file a motion to avoid a lien, check out the court's website and check out the guide for how to avoid a lien, and see if that's going to be helpful before you file one of those. So another thing on this front is to be on time to court. If you're going to be late, or if you have a courtroom conflict with another court, communicate. Communication is a key aspect of all this. So you need to communicate with the courtroom deputies about where you're going to be and why you're going to be late for wherever you're supposed to be at that particular moment in time. This means that you should have the courtroom deputy's name and phone number in your cell phone on like speed dial, and that you should be able to hands-free dial the courtroom deputy if you're stuck in traffic on I-85 heading to court and you're not moving and you're supposed to be in the courtroom. You need to be able to dial and say, hey, look, I'm stuck in traffic and I'm working on it, but I'm just not there yet. You need to communicate where you are so everybody knows and they're not kept waiting for you because there's more than you involved in the case. Communication is critical and key. Prong 4. What you learned in kindergarten. Don't forget to just look. So not all the bankruptcy cases are cookie cutter cases. These are people with problems, and we're problem solvers. We're not here with cookie cutter situations. They're all different. Every bankruptcy case is different. Don't assume that the exemptions or the values are going to be the same in every case. Don't assume that everyone wants to keep their home or keep their car, or that they should keep their home or they should keep their car. Listen to your client. Don't assume that you know what your client wants. Always ask your clients what their goals are. And if they're unreasonable, try to educate your client. Don't forget to look at each situation, each case as a unique set of problems and challenges. Be aware of the wonder of what we do as lawyers. Be aware of the wonder of each case. Pay attention to who your client is. Sometimes there's more than one client in the room or at the table. There's a business or 2 or 3 involved. There's a spouse. There's another entity. Do you know who you represent? Have you checked to ensure that your firm isn't also handling a creditor in addition to the debtor? Is there to the debtor and the creditor? Is there a potential conflict? Review the appropriate statutes for the matter at hand. Bankruptcy code is code-based. We live by the code. There's usually a specific statute and various subparts that are applicable to any issue at hand. Sometimes the specific statute makes a significant difference. For example, if a client owes a divorce-related property settlement, it's important to understand and know that a property settlement debt is actually dischargeable in a Chapter 13, but is not dischargeable in a Chapter 7. Conversely, an injury-related property debt may only be non-dischargeable in a Chapter 7 if it's willful and malicious, but may be non-dischargeable in a 13 if it's willful or malicious. But it must also be to a person, whereas in a Chapter 13 it can also be to property. Ask questions in different ways. Has your client spoken to a personal injury lawyer recently? If the answer is yes, there may be a personal injury claim you need to disclose. There may be nuances that matter. Sometimes the timing of the case may be critical. This may be the case if there are tax issues driving the case or divorce-related issues driving the case, if there's a car purchase involved, if there have been pre-petition payments or transfers that are associated with them, if there's a note that's been recently rewritten. It's critical to understand the true nature of all the assets and all the debts, and to understand who your client is and their entire economic picture and how all the situations interplay prior to a filing, so you can anticipate what might happen with the case and best represent your client without unexpected post-petition surprises. The surprise might actually be the value of something. You should know what the value of the somethings might be. The value might be something more optimistic if you wind up with a trustee who's actually going to check the value and not just take the value on the schedules. Try to meet with your client before the 341 or before the confirmation hearing. Shake a hand and ask if they have any questions. Answer them. Remember, there's a reason lawyers are considered counselor. So, our next prong. Don't forget to live a balanced life. The practice of law is stressful and demanding. Don't overextend yourself. If you're overwhelmed with work, both your clients and your family will suffer. Maintain a manageable caseload. Have the courage and confidence to turn away work if your plate is overflowing. Demand a reasonable hourly rate and a realistic retainer and pace yourself. At the same time, you need to take care of yourself. Take some time to exercise or do yoga, even if it's 10 minutes on a treadmill or walking up and down the stairs or around the block saying, with your eyes closed to mediate and center yourself. There are numerous apps available to help with meditation, yoga, exercise, step counting, walking, meeting colleagues to walk the Beltline or somewhere else. Just move a bit and start to do something healthy. The Atlanta Bar has started a wellness committee. The State Bar has #LawyersLivingWell and a link to physical well-being with a list of Atlanta area activities. Atlanta Track Club, 11 free places to exercise in Atlanta, running trails, golf listings, great places to bike, swimming in state parks, tennis courts. Check out Hiking Atlanta's Hidden Forest in Town and Out by Jonah McDonald. Eat in a healthy way. You only get one life to live. Live it well. No one else is going to live it for you. If you want to improve your cooking skills, take some cooking classes. Take them with someone important to you, be that a significant other, kids, dates. Take them locally or while on vacation and learn how to cook better and in more interesting ways. If you hate it, figure out a way to have healthy food brought to you in a way that works within your budget. Get enough sleep. Once the day, week, or year is gone, you can't get that time back unless you're Hermione Granger. So don't do things that you might regret. If drugs or alcohol become a problem, get help. There are resources out there. The State Bar has resources. And the link to that is in the materials. Do not wait until it's too late and you lose that license for which you worked so hard to get. Dress like a lawyer for court. Be a professional. I pulled a Huffington Post article on Dress for Success by Stacia Pierce, a contributor, life coach, career expert, and CEO. Ultimate Lifestyles Enterprises. This appears to be more geared for women than men, but it would be applicable for both. So, do you have a question, or are you just trying to hear? The light. So, questions before we continue? People, comments, judges, comments? No? All right. So, in a business setting, your appearance, it matters. Your dress, it educates others on how you want to be approached. Every time you go out, your image tells others how to treat you. They're sizing you up, making it an assumption of what you do for a living. Your income level and your current level of success in life based solely on your appearance. Dress for the role you want. Keep your look fresh and up to date. So the article talks about starting by clearing out your closet. It tells you to edit your old stuff out. It tells you to take the remaining items and put together outfits that take your appearance up a notch. It tells you how to make your closet more functional, how to play dress up for the week and wear your best looks to business meetings, and then gauge how people react to how you look, and to journal it to help you feel better. When shopping, if you find something you like, maybe buy more than one of it. When you're meeting with clients, doing presentations, always dress to impress. When you look your best, you perform at your best. Make a decision to upgrade your image and write an affirmation concerning your new look. Write down what you want people to say about you and include a description of how you feel when you dress your absolute best. Psych yourself up every day. You know, talk to yourself in the mirror. This is from the article. This isn't me, okay? You'll find it much easier to meet new people, express yourself, present in meetings, and even close the deal when you're looking and feeling your best. Do something today to upgrade your look so you can dress for success. So there's also a WikiHow for instructions with photos on how to dress very specifically for court. In summary, you dress as if you're going to church, which is conservatively. And there's a link in the materials. There's separate instructions for men and women. And this is actually a decent rundown for lawyers, but it's even better for clients. And it's important to be professional and respectful with your dress for court. And I put this in here not because anybody here needs it, but if you needed something for clients to share, whatever, it's there and you have it. So speaking of court, while you're in court and you're arguing an issue to the judge, you're an advocate for a position for your client to the judge. You are not arguing the issue at that point to opposing counsel. Each of you make and present your positions, your arguments, your case to the judge. Direct and cross-examination of witness is of the witness located in the witness box next to the judge. Eye contact is front and center. It's either to the judge or it's to the witness. The time for argument or discussion with opposing counsel who's beside you, either left or right, is before you get to the courtroom. It's either on the phone before you go to court, it's in the hallway before you enter the courtroom. Once you're there for the hearing, your discussion's front and center to the judge. You should have enough copies of exhibits with exhibit labels with you for your side, their side, the witness in the court. You should ask to approach the bench. If you know the order and what you need to introduce into evidence, the exhibit should be marked in advance. They should be exchanged with the other side in advance. You should try to get an agreement with what you can agree with will be admissible into evidence in advance, so it's clear where any disputes are. Sometimes this is great in theory. Sometimes it just doesn't work. But to the extent you can accomplish all this in advance, it makes for a far more efficient, easier, more streamlined adventure in court. I've been at hearings where a large firm, out-of-state lawyers billing close to $1,000 an hour have been unable to enter their evidence into the record, primarily because they've been unorganized and unprepared. So have a plan as to how you're going to get your necessary evidence into the record and coordinate, share with counsel in advance. It also helps to recognize in advance that there will be a contested hearing and schedule that matter in the appropriate calendar. And again, sometimes it's just not possible, but if it's possible, do it. So, 6, don't forget that we, like the goldfish, hamsters, white mice, and little seed in the styrofoam cup, we all die. Don't allow yourself to lose perspective. Don't get caught up in your client's emotions. Care about your clients. But remember that this is their life that's a mess, not your life that's a mess. Losing sight of all this will not only drive you crazy, but it will impede your ability to give your client sound, rational, objective advice. And this violates the lawyer's creed, which requires that you offer good judgment, and the aspirational statement on professionalism requires sympathetic detachment that permits objective, independent advice to clients. So I've determined that our bankruptcy world in Atlanta has its own life cycle. I'm not sure that it's the same anywhere else. It may be because we're Southern, even those of us originally from the Northeast. And it may be because of the limited number of judges and practitioners. Perhaps it's a combination of the above. But here's how it works. And this is why it's so important to be involved, get to know your colleagues, and not take on your client's problems and emotions as your own. So we attend the investiture ceremonies of our judges. We attend the receptions. We attend annual award programs to honor award recipients. We attend retirement ceremonies when the judges retire. We attend those cocktail parties. We attend funerals when colleagues pass and we pay our respects. At a certain age, some of these events seem to happen with a bit more frequency than others. There have been colleagues who have become seriously ill and who have passed on without family. Notably, the bankruptcy bench and bar went above and beyond in taking over the role of family in such situations. Other times, someone has become seriously ill and has become important for somebody to step in and look at an office full of open Chapter 13 files pro bono. And these files were all over stacks and stacks of 5 years worth of Chapter 13 files. And figure out what was going on, take them over and represent the clients whose fees have already been paid. And the lawyer wasn't there to do it. Somebody else needed to do it. It's imperative that you have colleagues who are your friends, who may be there when you have some unforetold need arises in the future to cover something that might need to be covered. Be that friend for someone else in a time of need. We are a community of bankruptcy practitioners. This is our world. This is something that's special about Atlanta. There's something special about Georgia practice and bankruptcy practice. Let's help keep it that way. At the same time, it's important to be in a position that your own life is one that is well lived without regrets. 7, don't forget to watch out for traffic, hold hands, and stick together. So the State Bar of Georgia aspirational ideal says, as to my colleagues in the practice of law, I will aspire A, to recognize and develop our interdependence, B, to respect the needs of others, especially the need to develop as a whole person, and C, to assist my colleagues become better people in the practice of law and to accept their assistance offered to me. Don't forget that clients come and go, but as bankruptcy lawyers, we'll be dealing with each other as professionals and hopefully friends for decades. No case, no client, no fee is worth losing a friend, damaging your credibility with the court, or developing a reputation as a jerk among your peers. What goes around comes around. We all need to watch out for traffic, hold hands, and stick together. There's an article at www.insofcourt.org on using legal skills in unexpected ways, how being a citizen lawyer can better the community and the profession. It's from August of 2019. It just came out. It's by Judge Linetti and Jennifer Eaton. Read the article. It talks about being a citizen lawyer. And it encourages people to enhance the legal profession through pro bono, running for office, seeking leadership in various positions in the legal and non-legal community. The article delineates all the innate skills we have as lawyers that facilitate our participation in numerous activities that work to make various communities a better place. We know how to do all sorts of things that we take for granted. We can read almost anything, critically analyze, advocate in an inordinate number of different positions, on point and off point, persuade, that would be argue, be good listeners, anticipate and guard against disputes, view situations from a number of different perspectives, focus on facts and logic rather than on emotion, draft and review legal documents, and negotiate with the goal of creating a whole that's much better than the individual parts. The article notes that these are skills we take for granted as lawyers, but we shouldn't underestimate their value in a multitude of environments for positive contribution to the betterment of society as a whole. My theme when I was the Atlanta Bar President was be an everyday hero, and I encourage people to just do little things to make the society a better place. That's what this article is really about. Go be the best you can be, and simultaneously serve our profession well and serve our city well. So, 8, clean up your own mess. Take control of your cases. Be proactive. Clean up your own mess and maintain control over your cases by settling your cases whenever and wherever possible. Take full advantage of every alternative dispute mechanism at your disposal, many of which are available at no cost from the bankruptcy court. Court available mediation. This is something also very special about our local bankruptcy practice. Be an adult. If something goes wrong, and it will, accept responsibility. Don't shift the blame to the paralegal, secretary, or the associate, or the lawyer that left the office or was on vacation. The cat did not eat the pleading. The baby may have been up all night, but ultimately, you are the lawyer responsible for whatever situation you are handling at that particular moment. Take a big gulp of air and face the music. This doesn't necessarily mean that you need to admit to malpractice. You can try to figure out a legitimate way to fix something if what has happened is that bad. But don't cover something up, don't shift the blame. Look counsel in the eye and admit what happened. Look the judge in the eye and say you're sorry and admit to what happened and ask permission to fix it. Identify a way to fix it. It looks worse for you if you try to blame someone else. Maybe you were responsible for supervising that someone else and that's where it went wrong. Ultimately, you're a professional and that was your responsibility. Accept it with grace. Do not think you can limit your exposure in a case by just taking a small piece and carving out the hard stuff. For example, if you represent consumer debtors in Chapter 7 cases and you take a small fee and think you're going to exclude yourself from handling any discharge-related adversary proceedings, beware of not allowing your client to enter default in a future filed complaint by not filing an answer. This has happened in cases, and lawyers have faced sanctions motions. Judge Bonifel has 2 published opinions that I found, Hampson v. Chase Bank, 429 Bankruptcy 360 from 2009, and then In re Egwim, is that pronounced right, Judge? Yes, Egwim. 291 Bankruptcy 559 from 2003. A lawyer must represent the debtor in connection with all adversary proceedings and contested matters filed in the case which may affect the debtor's rights and interests unless and until the lawyer withdraws in accordance with Bankruptcy Local Rule 9010-5B. And then Judge Deal has a published case called River City Bank v. Mathis, In re Mathis, 465 Bankruptcy 325 from 2012, discussing setting aside default for excusable neglect upon counsel's failure to answer. So Judge Bonifel in Egwim discusses 3 issues regarding a lawyer's responsibility in representing a Chapter 7 consumer debtor. And I really highly recommend that you read this case if you represent Chapter 7 debtors, consumer debtors. This is a really important case. 1, may the lawyer limit the scope of representation? Answer, no. Absent special circumstances, a lawyer must represent a debtor in all aspects of the bankruptcy case, including any contested matters or adversary proceedings that involve the debtor's interests. 2, what are the lawyer's duties up and until the court grants permission to withdraw pursuant to Local Rule 9010-5? Answer, the lawyer is required to represent the debtor unless and until the withdrawal requiring leave of court pursuant to Local Rule 9010 is granted. 3, under what circumstances will the court grant leave to withdraw if the circumstance is payment of fees or non-payment of fees by debtor to counsel? Answer, the court will consider fairness, reasonableness, and proper protection of the debtor's rights based on the circumstances of the case, and will allow withdrawal only if continued representation imposes an unreasonable burden on counsel that justifies withdrawal. Takeaway, ensure your fee structure contemplates representing the debtor in all aspects of these cases. The case law does not suggest non-payment for adversaries in contested matters. It allows a flat fee for the underlying Chapter 7 and additional fees for the other matters like stay relief motions and motions to avoid lien and adversary proceedings, but it does not allow the lawyer to abandon the debtor-client to a default in the underlying later filed adversary proceeding or stay relief or in contested motions. Because the cases all say if all you're going to do is the easy stuff, then you're really not much better than a petition preparer. 9, don't forget to wash your hands before you eat. And that means don't forget to turn off your cell phone or at least set it to vibrate before you enter the courtroom or 341 room. That's basic bankruptcy court hygiene. And 10, don't forget to flush. 2 + 2 = equals 4. If your client needs a math lesson, give him or her a math lesson. If they still can't count, fire them. It's really critical to be honest with the court. Bankruptcy is about honest disclosures. Both you and your client need to understand the need for honesty and candor to the tribunal. Remember that one case or one client is not worth tanking your reputation or the license for the duration of your career. You need to follow the withdrawal procedures of Local Rule 9010-5. So now we've got some time left, so I want to open it up for questions and comments from the bench. Questions, comments, talk, people talk. Yeah, go ahead. Say something. You're just waving. Yes.
Do you want to talk a little bit about emails and their role in professionalism?
As far as what? Like copying things? What do you have in mind?
No, I just found that oftentimes when I was on the bench and you get into people trying to either present evidence or just talk about what had been transpired between people, and they're all about reading you emails between parties. And I mean, it raises sort of two issues. One, I think professionalism is really about building relationships with your client, relationships with other lawyers, and relationships with the court. And you don't build relationships by just emailing people, particularly when you're in a peak of anger or frustrated or anything else. So my advice is be cautious about what you email. It's one thing to confirm we're doing a deposition or we're doing a meeting at this date and time. It's another thing to try to argue the substance with the other side. And by all means, don't try to show those to the court. Don't attach them to pleadings. I mean, I think we actually have a local rule about that, but it's ignored. So I guess it's two things. One is be very cautious about how you use them just in your practice, but also how you show them to the court and what you use them for in the court.
Thank you. Other comments on that front? There's an evidentiary problem if you try to attach an email to a pleading or something that they're really not supposed to be attached. And it's also not, it's better to pick up the phone and call somebody and actually have a conversation. Not such a good idea to go back and forth by email. Other thoughts, comments? People? Joe, do you want to talk about EGWIM a little bit, since that's like really important?
I really don't know that I have anything to add, actually, except that it's designed, that whole idea, it's not my idea, it's the local rules idea, but a substantial part of it is in the consumer debtor context, but really in any representation. But I understand that there are cases that are going to be expensive to litigate and the debtor can't afford it, and nothing makes you have to provide services for free. But you do have a responsibility to at least talk with the debtor about it, tell them what it's about, explain the law to them, explain how they would have to represent themselves if they don't have a lawyer. And we are blessed by the Atlanta Bar Association's pro bono representation. Greg Tobby, I guess, is still doing it. But there are lawyers who will undertake cases on a pro bono basis where the debtor can't afford the representation. So, again, and then, having done all of that, and given what I call giving the debtor a fighting chance to do it pro se, then you can file your motion to withdraw and you know, see what happens. But if the debtor can't pay for fees, that's probably going to be a reason to permit the lawyer to withdraw, because you don't have to work for free. While I'm here, and briefly on the email issue, the other thing that occurs to me, and maybe this is just because I'm from the dinosaur age, but a lot of the times, you know, stop the email and pick up the phone and call opposing counsel and talk through the issue. And talk through the issue instead of trying to resolve it by emails that just go back and forth and don't accomplish anything.
I will say on the 727 discharge, 523 discharge issue, at the start of a case, if you've done your vetting and you have an understanding of the issues in the case, and you've actually like had a chat with the client and understand what the case is about on the front end, you ought to have an idea of whether there's going to be discharge litigation that you need to be on guard for before the case starts. So 523, 727 shouldn't be a tremendous surprise. So you ought to be able to anticipate that when you file the case. So it just shouldn't be a tremendous shock. I mean, I guess sometimes it is, but yep. All right. Other thoughts, comments, chime in, questions? Yep.
I represent a lot of different debtor firms, and a firm called me today and said, we're looking at expanding our bankruptcy practice. What should we do better? And I said, this isn't just your firm, but for everybody I represent, the one thing I want you to do is talk to the trustee. Talk to the trustee before the hearing. There should never be a case where you file your whatever you were filing right before court, and the trustee gives you a reset so they can review what is filed, and you come back a month later and you've never spoken with the trustee and you don't know what the issues were with what was just filed. And it happens all the time. And I walk up to the trustee and I say, the debtor's counsel believes everything is good in this case, and they say, no, everything you did last time was wrong. And that should never happen. It should be worked out. It should never happen without the debtor's counsel knowing beforehand that there were issues, because they should have spoken to the trustee a week before that hearing.
I think that's an excellent point. I think communication is critical. I think, you know, we're professionals, and we've got, you know, you get asked a lot for opposing counsel in different situations. You ask for opposing counsel. And bankruptcy is really not designed that way. We don't have, you know, we'll be in situations where, you know, I have an adversary proceeding and Leon's my opposing counsel, or Neil as trustee is my opposing counsel. But it's not really like that, because we have all these different parties, you know, and yeah, I'm representing a Chapter 11 debtor, and I'm debtor's counsel, and, you know, then there may be 25 or 70 different creditors, and some of them have counsel, and then there's the U.S. trustee, and then, you know, you just got all these different parties and interests. And in a Chapter 13 case, you've got debtor's counsel, and you've got the debtor, and then you've got all these different parties. And, you know, communication is critical, and keeping track of who's interested in what, and what the different parties' interests are, and how to resolve the different interests. It's a different animal than a lot of different practice areas. And communications, I think, part of our job as professionals and bankruptcy practitioners, and it's very important. And I think that the firms that have very high volume, it's a trick in trying to figure out the best way to keep all those balls in play, to keep the communication going, and to have the relationships with the trustee's office, to have that communication on the front end, so they don't walk into the courtroom trying to figure out who the client is, what's going on with the particular file, and have we done what we need to do before we kick it out another another calendar and come back again and try it over again. I think that's absolutely a fabulous point. Another point discussion. Got time for at least one or two more points. Come on, surely somebody else has another question point. Silence. What? No, that's from the other side of the bar.
sort of goes hand in hand with what you just said, but the one of the lessons was clean up your own mess. Well, for better or worse, I think as practicing attorneys, you don't just have to clean up your own mess, you also have to clean up the mess of your clients and the mess of your colleagues within your own law firm, or if you're co-counsel, the mess of your co-counsel. And one of the I know that this was in the list from Judge Hagan, I believe, one of the things that we hear a lot when we run into issues in court is, oh, somebody else in my office did that, or a different attorney did that. And I appreciate that is absolutely what happened. But to some extent, the court doesn't necessarily know what to do with that. I mean, we're still where we are here today, and we still have to kind of deal with that situation. And I think to your point, if attorneys stopped doing that and just instead had to take responsibility for whatever the situation was that they were standing there dealing with, I think that would really sort of encourage everybody to do better. I mean, if all of a sudden you have to take responsibility for your colleague's mistake, you're going to be pushing on your colleague a little bit harder in the office to do it right in the first place, and then that makes things easier on everybody, because I hear what you're having to face, and that's not an easy thing either. So I do think that taking responsibility is not only a good thing for yourself and helpful to the court, but I think it encourages just everybody to do better.
I think to that point too, that's like fair to the client. I mean, here are these people who have real problems, and we're problem solvers. As the lawyer, they come to us with these problems, and they don't really know what their problem is. They come to us, and like in law school, they've just got a set of issues, and half the time that they don't even know they don't know how to solve their problem. Sometimes they don't know who the client is. They just have a situation. They're looking for a way out, and you're the problem solver. They don't know. In the larger situations, they don't know who their lawyer really is. When they're looking to find their lawyer in court, they're looking for a solution, and you're their answer, and they're looking to you to solve their problem, and that's part of your job, is to solve their problem within the confines of our bankruptcy code. And the goal of the program is to say don't take on their emotions and don't take it personally. But it's still, these are, when you read the cases and the materials about not letting the clients default, Judge Deal and Judge Bonnefeld talk about how the clients are these are real individuals, and they have real situations, and they're looking for help, and we're here to help them. We're counselors here to help real individuals with real problems, and as professionals, we need to keep that in mind, that we're really helping individuals. They're not just the case number being pushed through a machine operation where we're just pushing paper. So I think that's our hour. And unless anybody else has a comment, question, concern, we are done. And I really, really appreciate everybody coming out tonight. Thank you.
Well, thank you, Shayna. That was really interesting and informative. I think we did learn everything we need to know to do this job in kindergarten, or maybe before. But I really did find that very interesting, how you managed to weave that all in with our professional responsibilities. Thank you again for a really wonderful presentation. Did you have some announcements?
Just a couple of housekeeping items for MACBAG. First of all, thank you so much, Shayna. We really appreciate it. Just so everyone knows, it's not easy to get a professionalism CLE approved. They've got some real strict guidelines, and she just really put in the work, and it was a really great presentation. As far as CLE credit is concerned, if you do want to get CLE credit and you have not completed a form for me, please come see myself or Salone at that table over there so we can get you signed up and I can get your bar information. As far as our September meeting, I will send out an email letting you know when, where, and what's going on for MACBAG. And lastly, as far as the CLE is concerned, there will be a survey that you need to take. I will send it out via email if you have signed up, because I have your email address. Otherwise, I think that's all I have for housekeeping. And again, thank you, Shayna. Appreciate it.